Hi, so the court case that I was assigned was Board of Education of Westside Community Schools v. Mergens of 1990. And this case ultimately went to the Supreme Court. The case itself decided if the Equal Access Act prohibits Westside High School from denying a student religious group permission to meet on school premises during non-instructional time, and if so, whether the act violates the Establishment Clause of the First Amendment. So first, I wanted to go over what the Equal Access Act of 1984 is, and I got that information from the First Amendment Encyclopedia. And basically, it forbids public schools from receiving federal funds when they deny students the First Amendment right to conduct meetings because of religious, political, philosophical, or other content speech at such meetings. Additionally, the Establishment Clause, Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof, of freedom of speech or of the press, or the right for people to peaceably assemble, and the protection of the government. And I got that information from constitutioncenter.org. So what happened in this case is in January of 1985, Bridget Mergens met with Westside principal Dr. Finley and requested permission to form a Christian club at this school. So this club would have all the privileges to meet on the same school terms and under conditions that other Westside school clubs had, with the exception that they wouldn't have a school sponsor. And according to the students' testimony at the trial, the club students would be allowed to read and discuss the Bible, have fellowship, they would be able to pray with each other, and things like that. Another thing that was noted was that the involvement in this club was completely voluntary, and it didn't matter what religious affiliation, everyone was invited, but it was completely voluntary. So the principal ultimately denied the request, and the associate superintendent also denied the request. So in February of 1985, they informed Mergens that they had discussed the club and decided that it would be denied. So a main argument for this would be that the school actually requires teachers to be sponsors. They needed a faculty sponsor. And because this was a religious club, they could not have a faculty sponsor for it. And that a religious club at the school would violate the Establishment Clause. So in March of 1985, Mergen appealed the denial of the request to the Board of Education, but the Board of Education ultimately decided to side with the principal and the superintendent and denied the club as well. It was later brought into question if the denial of the club went against the Equal Access Act, which prohibits public secondary schools that receive federal financial assistance and a limited open forum from denying equal access to students who wish to meet within the basis of content of speech, and that I discussed a little bit earlier as well. And so they also argued that the petitioners' actions denied from their First and 14th Amendment rights of freedom of speech and free exercise of religion. So that's kind of what Mergens' side was arguing, was that it was free exercise of religion and freedom of speech. Limited open forum was defined as whenever a public secondary school grants an offering or opportunity for one or more of non-curriculum related student groups to meet on school premises during non-instructional time. And so Westside did not have that. Additionally, I want to define non-instructional time, which is time set aside by the school before the actual classroom instruction begins or after the classroom instruction ends. So it's any time that is not within a class, is not within class time. The Act also specifies that the school should be deemed to offer a fair opportunity to the student who wish to conduct a meeting within its limited open forum. And if the school provides that meetings are voluntary and student initiated and are not sponsored by the school at all, then it's considered non-school persons and non-instructional time. And the final argument is that by complying with the Act's requirements, the school risks excessive entanglement between government and religion, and that was a big concern for the school to have that connection between education and religion. Ultimately, so the court actually did find that some of the clubs within the school were actually what could be considered non-curriculum related, such as like the chess club. So the argument that there is not a limited open forum didn't really hold, because there were clubs that are non-curriculum related as well. The final decision was that distinguishing between curriculum and non-curriculum student groups, the Supreme Court held that since Westside permitted other non-curriculum groups or non-curricular groups, it was prohibited under the Equal Access Act from denying equal access to any other school club based on contents of his speech, such as religion. So my final thoughts of this is that it can be really, really hard to say what the right decision is, kind of depending on how you look at it. Overall, I believe that the right decision was made because it's not faculty led and because it doesn't have curriculum ties or educational ties to the school. I believe that within the non-instructional time and without a teacher or faculty involvement, it does still keep that boundary between religion and education, which was a main cause for concern for the school. And I think that by defining it as a non-curriculum time, that they made the overall right decision.